So welcome to Jumbo IS and welcome to our lecture series called Prelims Powerplay. In this lecture series, we cover entire 1 year's current affairs. What we have done is we have divided the entire 1 year's current affairs into subjects and we cover each and every subject one by one. The purpose is that you get to revise important topics just before your prelims examination. Now currently we are on the subject of polity. And one lecture of polity has been done away with. It's over. So if you want to cover that portion, please watch our previous lecture. Today we are going to cover the topic of parliament in polity section. Okay, polity subject. So all the important news items, all the important current affairs with respect to parliament in past 1 year shall be covered in today's lecture. Okay, so let's begin today's lecture without further delay, without further ado. Alright, so let's begin today's lecture. Parliament. Okay, now within Parliament, here are the following topics that we shall cover. Okay, so these are the topics, these are the important topics that featured in newspapers in the past 1 year. That's why we are covering them. They are very important. Okay, so listen carefully. So these are the topics that we are going to cover in today's lecture. Number one is unopposed election victories. Supreme Court has taken cognizance of this scenario. There are some issues with respect to this unopposed election victories. Okay, then Parliament basically introduced Immigration and Foreigners Bill 2025. So we'll talk about this. Then we'll talk about resolution for removal of Vice President. Okay, this never happened in our country. No resolution for the removal of Vice President had been passed before in our independent India's history. So we'll talk about this first in the history event. Okay, then we'll talk about the words socialist and secular in our preamble, how they were introduced, what was the purpose behind them. Then we'll talk about the issue of one nation, one election. Then we'll talk about the controversy regarding money bill. Okay, and in the end we'll talk about, well, Enemy Properties Act. Okay, because it was in the news. Clear? So let's begin today's discussion with unopposed election victories. So here is our topic number one, which is unopposed election victories. Okay, so unopposed election victories. Why was this in the news? The thing is that, well, in our country, elections take place. And for elections, the entire country is divided into constituencies. So whenever general election for Lok Sabha take place, the entire country is divided into constituencies and there is an election in each and every constituency. We all know about it. But there are some constituencies where there is no candidate fighting for the elections except one. That candidate is declared a winner unopposed because no one is fighting against him or her. Okay. Therefore, there is no need to conduct the election process. Okay. So if there is only one candidate contesting from a constituency, he is declared winner without the election process. Now, there are a few people who think that election process should still be conducted, even if there is only one candidate fighting elections. Okay. Now, what is this issue? In fact, those people say that if you are not conducting elections, then that is a violation of our fundamental rights. Elections still should be conducted, even if only one candidate is fighting elections from one constituency. Now, what is this issue all about? Okay, what is this case that is currently lying pending in the Supreme Court? Let's talk about this. Okay, so unopposed election victories. Okay, so what is the case? Now, the thing is that there is this organization, this civil society called Vidhi Center for Legal Policy. Okay, they have filed a petition in the Supreme Court saying that if there is one person fighting elections from one constituency, well, elections should still be conducted in that area. Okay, because if you do not do that, well, that is a violation of our fundamental rights. Now, Supreme Court, while hearing that case, well, made a remark. Supreme Court did not make a judgment. It just made a remark. It said that elections should be conducted and for that unopposed candidate, if he needs to be victorious, if he wants to be victorious, then he needs to secure minimum number of votes. So even if there is one candidate, there should be election and he shall be declared victorious only if he secures, let's suppose, 10% of the votes or 15% of the votes. There should be a minimum threshold. Now, Supreme Court hasn't given a judgment. It has just advised maybe this can be done. Okay. Now, what fundamental rights are being broken if this candidate is declared victorious without the election process? Basically, Vidhi Center for Legal Policy was challenging Section 53, Clause 2 of the Representation of People's Act. Section 53, Clause 2 of Representation of People's Act says that if a candidate is contesting elections and he is unopposed, then he should be declared victorious without the election process. That is a law. In this law, Representations of People's Act says that unopposed candidate shall be declared victorious without the election process. Okay. Now, Vidhi Center for Legal Policy is basically challenging this Section 53, Clause 2. They are saying that this is a violation of fundamental rights. Now, how is this a violation of fundamental rights? Okay, let's talk about this. So, the thing is that in 2013, Supreme Court gave a judgment. Okay, and through that judgment, this was introduced, nota. You must know about this. If you have casted your vote ever in your life, you know this, that when you go to cast your vote, well, there is an EVM, electronic voting machine, in front of you, and there is a list of candidates on that. Okay, and along with each candidate's name, there is a button. If you press that, then you vote for that candidate. But in the end, there is this button which says none of the above, nota. Okay. Now, nota means, if you are pressing nota, that means you are not happy with any of the candidates contesting elections in your constituency. Now, Supreme Court in 2013 said that nota should be there, and nota is basically, the facility of nota is basically your fundamental right of freedom of speech and expression. Because if you are unhappy with all political parties, then too you have the right to express your opinion. So it is part of your freedom of speech and expression. And freedom of speech and expression is Article 19, Clause 1, Subclause A. It is a fundamental right. Okay. So pressing nota button is your fundamental right. Now, Vidhi Center argues that if there is an unopposed candidate and you are not conducting elections, then people in that constituency do not have the opportunity to press the nota button. When they do not have the opportunity to press the nota button, well, that is a violation of their fundamental rights as per Supreme Court in 2013. So, not holding the election in case of single candidate prevents voters from choosing the option of none of the above, which is your freedom of speech and expression, your fundamental right. So, Vidhi Center says that elections still should be conducted so that people have the opportunity of pressing the nota button. And Supreme Court also says, or Vidhi Center also says, that unopposed candidate should also secure a minimum number of votes to get elected or to be declared victorious. Clear? Now, some of you might be thinking that, well, unopposed candidates is a rarity. Okay. Every time there is someone to contest elections, we rarely see this unopposed candidate scenario. Well, the thing is, it is not so rare after all. Okay. Now look at this. Since 1951, when the first elections were conducted, till 2024, when the latest elections were conducted, there have been 26 constituencies where people have been elected unopposed. The latest one was in 2024 from Surat. A BJP candidate was declared victorious because no one fought against him. Okay. Of these 26 no contests, 7 took place in 1957, 5 in 1951-67, and the latest one was in 2024. Okay. Now, Vidhi Center agrees that when it comes to center elections, Lok Sabha elections, unopposed candidates is a rarity. But unopposed candidates is quite rampant in state elections. Okay. Vidhi Center agrees that uncontested elections are more common in state assemblies. Clear? So this is an issue and Supreme Court is currently deciding upon this issue. Clear? That would be all. And let's quickly jump to second topic, which is Immigration and Foreigners Bill. Okay. Now the thing is that India has this problem of illegal migration, especially from Bangladesh. Okay. Though we have a case of illegal migration from Myanmar also, Rohingya Muslims. Okay. But Rohingyas. But we have an issue of illegal migration, and most of it is from Bangladesh, and that is because with Bangladesh, India shares a porous border. Now, India has various laws that deals with illegal migration, but there are some problems in those laws. Okay, there are various problems in those laws. Therefore, Indian government decided that we need to reform those laws, we need to upgrade those laws, and we need to make those laws more strong so that we can tackle the problem of illegal migration, because illegal migration is a problem. If you want to come to India, come legally. But if there is illegal outpouring of people into India, that creates a lot of problems. Okay. So for that purpose, for reforming our legal architecture with respect to migration, illegal migration, well, we came out with this Immigration and Foreigners Bill. Basically, what this bill does is all the previous laws, it replaces all the previous laws, it combines all the previous laws into one, replaces them and combines them into one. So from now on, India will have only one law which deals with illegal migrants and foreigners. Okay, one law instead of multiple laws. So it first of all reforms this problem that we have multiplicity of laws. Okay. Second of all, it has some controversial provisions also, which the opposition party members are basically opposing. So let's talk about this. Okay. So Immigration and Foreigners Bill 2025. It is just a bill. It has not become a law. Okay. It was introduced. So about this bill. So basically this bill was introduced by Minister of State for Home Affairs. Okay. Now what this bill does is it proposes an overhaul of India's immigration laws. So India had various immigration laws. This law will replace all of them. Okay. So the older laws were as following: Foreigners Act 1946, Passport Act 1920, Registration of Foreigners Act 1939, and Immigration Carrier Liability 2000. As you can see with these dates also, most of these laws are British era laws. Now, conditions were different during that time. Now it is 21st century, conditions have changed, circumstances have changed. Therefore, we need a law that is up to date with the current circumstances. That is why there was this need to replace the old laws, because most of these laws were colonial legacy, except the Immigration Carriers Liability Act. Okay. So first purpose was to do away with colonial legacy. Second purpose was to reduce this multiplicity of laws. We need one simple law instead of many. Okay. The other objective was enhance national security. So the objective of this law is enhance national security, because illegal migrants, well, jeopardizes your national security, because through these, well, basically these illegal migrants come through various human trafficking gangs. So this promotes organized crime. Sometimes terrorists infiltrate in your country, criminals infiltrate in your country. So this is a national security problem. Then control immigration procedures. This is another objective. Introduce stricter penalties on foreigners who violate entry and stay conditions, so that this law acts as a deterrent. By deterrent, I mean that anyone who is thinking about illegally migrating to India should think twice, because they know that the punishment is severe. Clear? Now, there are a few controversial provisions in this bill. Okay. Now, let's suppose there is an illegal migrant and he or she is identified. The matter would go to the immigration officer, and the immigration officer will take a decision whether to deport that person, imprison that person, or whatnot. The thing is that earlier, whatever decision was taken by the immigration officer, well, if you felt that it was a wrong decision, you could appeal against that decision in the courts. Right? And the courts would give you justice. Now, in this new law, it is said that no appeal lies on the decisions of immigration officer. Decision taken by the immigration officer shall be final. And opposition parties are basically opposing this, because they say that this immigration officer would be from the government of the day. So government can remove anyone, identify anyone as illegal migrant and remove them. Okay, government's biases or the ruling party's biases can come into the picture. This is also an allegation, by the way. Okay, so this is a controversial provision. Though the benefit is that this law will simplify earlier British era laws. Clear? Plus, one more good thing is added in this law. This law has the provision of centralized tracking of all illegal migrants across all states. So this would ensure better tracking of illegal migration. Clear? So that's it. That's all you need to know as far as this topic is concerned. And now let's move on to topic number 3, which is resolution against vice president. Basically, this resolution is for removal. Now, the thing is, we have a president in our country, okay? And president is an important office. Now, if the president is unable to discharge his duties because of illness or any other reason, okay, then temporarily his duties are discharged by the vice president. So the purpose for the office of vice president is to basically compensate for the president if he or she is unable to discharge their duties, okay, until new elections take place and new president is appointed, okay. Sometimes there is an untimely death, illness or whatnot. Now, vice president has another role. Look, to preside over the proceedings of Lok Sabha, there is a speaker. To preside over the proceedings of Rajya Sabha, there is a chairman. Now, Vice President of India is the ex officio chairman of Rajya Sabha. So, Vice President of India has another duty. He has to be the presiding officer in chief of Rajya Sabha. Right? Now, if members of Lok Sabha are not happy with the speaker, well, they can pass a resolution to remove him. If members of Rajya Sabha are not happy with their chairman, well, they can pass a resolution to remove him. But if they are removing the chairman, they are also removing the vice president also. So, in effect, in a way, that removal procedure for chairman is also the removal procedure for vice president of India, because vice president of India and chairman are one and the same thing. Now, never in India's history has ever been a resolution passed to remove vice president. But this record was broken last year. Okay, never in India's history, well, Rajya Sabha has passed a motion to remove the vice president or chairman of Rajya Sabha, but last year they did. So it was first in history. Okay, now what was the controversy? We shouldn't be concerned with that. But we should know the procedure to remove Rajya Sabha chairman or vice president of India, because a static MCQ can be asked from this. Okay, so let's talk about that. So resolution for removal of vice president. Okay, so what is the constitutional provision? Clear? Under Article 64 of the Constitution of India, Vice President shall be the ex officio chairman of Council of States. And Council of States is nothing but Rajya Sabha. Okay, so Article 64 says Vice President is the chairman. Now, since Vice President and Rajya Sabha chairperson must be the same individual, the process for their removal is also the same. And the process for removal of Vice President or Rajya Sabha chairman is mentioned in Article 67. Remember this fact. Okay. Now, what does Article 67 say? Vice President shall hold office for a term of 5 years from the date on which he enters upon his office. So, as soon as the Vice President is elected, his term is 5 years. Until the Vice President resigns so his term is fixed, 5 years. But his term can be cut short if he resigns or if he is removed. Okay, so this term of 5 years can be cut short if the Vice President himself resigns by writing to the President or he is removed. Now, what is the removal process? That is mentioned in Clause B of Article 67. So, what is this Clause B? Article 67, Clause B. It says that if majority of all the then members of Council, Rajya Sabha, passes a resolution for his removal, which must then be agreed to by House of People, that is Lok Sabha, then he shall be removed. Okay, make sense? So a resolution needs to be passed in Rajya Sabha, and that resolution should receive the vote of majority members of Rajya Sabha. Okay, then that resolution has to be agreed to by Lok Sabha, then only he can be removed. Now, what do I mean by this term majority? Okay, well, there are 4 types of majority. Okay, number 1 is simple majority. Let's suppose Rajya Sabha has 252 members, but only 100 members are present. So, simple majority means you need at least 50 votes. Okay. Then there is absolute majority. Okay. Let's suppose only 100 members are present, but the full strength of Rajya Sabha is 250. So, you need at least 125 votes. Okay. That is absolute. Then there is effective majority. Let's suppose again Rajya Sabha has 250 members, only 100 are present. And the thing is that from those 250, 10 seats have 10 people who were elected to Rajya Sabha, their elections have been called into question, their seat is vacant. Okay, they have been disqualified. So now the strength of Rajya Sabha is 240. So effective majority means you need at least 120. Okay, and fourth is special majority. Special means 2/3 vote. 2/3 of members present and voting, plus another condition is that the 2/3 votes should be at least more than absolute majority, that is 125. That is special majority. It is used for constitutional amendment. Okay. Now remember, if Rajya Sabha wants to remove its chairman, then the resolution has to be passed by effective majority. And it has to be agreed to by Lok Sabha by simple majority. So basically, if you have to remove vice president, effective majority is required. Okay. This is what is written in Article 67B. One more thing is written. Okay. It says that no resolution for the removal of vice president shall be passed or shall be initiated unless a 14-day notice has been given. Okay. So if you want to pass this resolution, first you have to give a notice of 14 days. Then after 14 days, this resolution is admitted, put to vote, and if there is effective majority, he is removed. Okay. And plus it needs to be agreed to by Lok Sabha also. Clear? That's all. That's all you need to know as far as this topic is concerned. And now let's quickly jump to topic number 4, which is socialist and secular words added in preamble. Now, the thing is that our preamble is basically a precursor to our constitution. Okay. The preamble is an introduction to our constitution. It basically highlights the basic philosophies of our constitution. What this constitution is all about. That's what's written in preamble. Now, do you know that, well, our preamble was changed in 1976. When our constitution was adopted in 1949, 26 November 1949, it was different and a few words were added in 1976 through 42nd Constitutional Amendment Act. Okay? Yes, that is the case. Now, those few words included the word socialist and secular. Okay? Earlier constitution did not have the word socialist and secular in its preamble. But then through 42nd Constitutional Amendment Act 1976, these two words were added. Now recently, some people are objecting to these two words and they have basically filed petitions in the Supreme Court saying that these two words were not the original intention of the constitution makers, therefore they need to be removed. Okay, that's the controversy basically. Okay, so let's talk about this issue. So, socialist and secular words in preamble. So, as you can see, this is the constitution as adopted on 26th November 1949. And this is the constitution which is present. Okay, so this is the preamble of our constitution when our constitution was enforced. This is the current scenario. Okay, as you can see, it reads, "We the people of India having solemnly resolved to formulate India into a sovereign democratic republic." Okay, these were the words used. Whereas in the present case, sovereign socialist secular democratic republic. So the words socialist and secular were added, and these additions were made through 42nd Constitutional Amendment Act 1976. Now the thing is that 42nd Constitutional Amendment Act is also known as the mini constitution of India. Why? Because so many changes were introduced through this. So many changes. Okay. Some of those changes were deemed unconstitutional by the Supreme Court later. But Supreme Court did not deem these two additions, socialist and secular words in our constitution, unconstitutional. Supreme Court allowed these two additions, and that is why these two additions still exist. Okay. Now, to understand this controversy a little better, let me share a few facts with you. Look, the preamble is basically inspired from the objectives resolution moved by Jawaharlal Nehru in the Constituent Assembly on December 13, 1946. So when our Constituent Assembly was formed, the task to the Constituent Assembly was to frame a constitution. Okay. Now within first week of that Constituent Assembly on December 13, 1946, Jawaharlal Nehru basically introduced objectives resolution. It was basically an 8-point resolution. And these 8 points basically enshrined the basic philosophy of our constitution. Okay. The guiding principles. Okay. That these are the guiding principles which we look upon before framing this constitution. Okay. And the preamble of India is directly inspired from this objectives resolution. Now the thing is, well, when our constitution was enforced or when our constitution was enacted, preamble was also enacted, right? Now, do you think that, well, the constitution makers deliberately did not add these two words, secular and socialist, in our constitution? Deliberately, they did not add these two words. Yes, India is a secular country. Yes, India, that's debatable whether it's a socialist country or not, but they deliberately did not add these two words. In fact, when the Constituent Assembly was discussing constitution, there were a few members who wanted to add these two words. Okay, there was this amendment introduced by Hasrat Mohini, a member of Constituent Assembly. He said that India's name should be UISR, like USSR, Soviet Union, United Indian Socialist Republics. Okay, United Indian Socialist Republics. Like USSR, we want to become a socialist economy. In fact, K.T. Shah, another member, he also said that the word socialist should be added. But our constitution makers, well, they deliberately refrained from using these two words, socialist and secular, in the preamble. And there is good reason for that. The reason is, well, secular means separation of church and state. Secular means, Western secularism means that state has no business in religion. State will be completely separated from religion. But in India, Indian secularism is different. In India, state interferes in religion, but state is equidistant from all religions. Basically, Western secularism is state is away from religion. Whereas in India, secularism means that state is not away from religion. But the thing is, state will not favor one religion over the other. This is Indian secularism. Back then, there was no clarity over the word secularism. Which definition would India follow? Western or Indian? That is why constitution makers thought that this would add confusion, so we should refrain from this word secular. The socialist word was not added because, well, the thing is, some constitution makers thought that we shouldn't basically tie our economy to socialist principles. India will decide whether it wants to follow capitalist system or socialist system. Okay, so we should not bind our population with this word. That is why these two words were not added. Clear? But recently, in 2010, a petition was filed to remove these two words that were added by 42nd Amendment. Okay? And they gave the same arguments which I gave. But Supreme Court refrained from that. Supreme Court said that no, these words will stay. And the thing Supreme Court said was that secularism, now India has a proper definition of Indian secularism. Therefore, this word secular means Indian secularism. And the word socialism in India's case doesn't mean that, well, we are following the Soviet Union model. Socialism means that, well, we will think for the poor, equality of opportunity would be given to the poor, and private businesses would also be allowed in India. So socialism is also in Indian context different. Therefore, there is no problem with these two words. That is it. That is all. Okay. And now let's quickly jump to next topic, which is, well, one nation, one election. Okay. Now the thing is that government says that in India, every time, every year, we are ready for elections. Elections are there in some state or the other every year, around the clock. Okay, central elections are there every 5 years, but state elections are there every year or so. Okay, some state elections are there, then next year some state elections are there. Now, central government believes that this puts a burden on basically, government machinery. Okay, this puts a lot of burden. Plus, the politicians are also not free from their election mindset. They cannot focus on governance for Indian people because most of the times they are busy fighting elections. Therefore, elections for the state, elections for the center should be conducted simultaneously once every 5 years. This is what we mean by one nation, one election. And Government of India actually formed a committee under the chairmanship of former President Ram Nath Kovind ji, okay, to advise the government how to introduce one nation, one election. Okay. Now, Ram Nath Kovind panel gave its recommendations and cabinet gave its approval to those recommendations. So, one nation, one election can become a reality in the near future. Okay. Now, what is this one nation, one election? Let's talk about few important points. So, some recommendations were given by Ram Nath Kovind panel. Okay, what were those recommendations? Well, you need to amend the constitution. 3 articles of the constitution need to be amended so as to allow for one nation, one election, and 12 new sub clauses should be added. Okay, and 3 laws related to union territories which have assemblies, they also need to be changed. Plus, the panel said that a single election roll, electoral roll for both central and state elections shall be created by Election Commission of India. Therefore, for that, you need to amend Article 325 also. Plus, local body elections, panchayat and municipality elections shall be conducted 100 days within 100 days of center and state elections. And if a state gets dissolved way before 5 years, then the new election shall take place and the new state assembly shall continue for the remainder of 5 years. Okay, so that there is no discontinuity between center and state elections. Clear? So synchronization would happen. Now, what are the advantages of one nation, one election? Well, consistency in governance, because our politicians won't be distracted. Plus, most of the times, because political parties are distracted towards fighting elections in one state or the other, resources are also, political parties' resources and state resources are also directed towards these areas. Okay, so resource diversion happens. These resources can be used to help the poor. Then it will reduce financial burden. Plus, if every time we are fighting elections, then we need security forces for that also. So our security forces are also distracted for conducting elections. Then it conducts policy paralysis, because whenever you are fighting elections, model code of conduct is enforced, and in that model code of conduct, government cannot introduce new schemes. So this creates policy paralysis, and this reduces the focus on governance and more on elections. So if one nation, one election is there, then all of this would be done once every 5 years, and for the rest of the 5 years, well, the government would be, or the politicians would be, free to focus on governance. So this is the advantage. But there are many disadvantages also. But I don't think they'll ask you any MCQs with respect to disadvantage. Okay, there are many issues though. but they won't ask questions. Issues like, well, it is against federalism, because people would be confused between central issues and state issues before voting for a candidate. Okay, people need to bifurcate between the two. Plus, it would put a lot of burden on election machinery, because conducting simultaneous elections in center and states require a lot of EVMs, lot of state machinery. So it is a difficult challenge, but government is hell-bent on conducting these elections quickly. Clear? And that would be all. Let's now shift focus quickly to next topic, which is money bill. Okay. Now, what is money bill? The thing is that there are certain bills introduced in the parliament which are related to finance of India, purse of India, public purse of India. Now, our constitution makers wanted that the purse of India or any law with respect to financial resources of India, well, that law should be made by representatives of people, okay, not representative of states. That means Rajya Sabha. People who are directly elected to the parliament should be in charge of, well, financial purse of India. Okay, that is why if a bill is introduced in the parliament and that is a money bill, well, the sole responsibility lies on Lok Sabha. Lok Sabha has the entire power. Okay, Lok Sabha passes that bill, Rajya Sabha is just a recommendatory body. But sometimes what happens is that sometimes the ruling party, if it does not have numbers in Rajya Sabha, they disguise a normal ordinary bill as money bill and pass it through Lok Sabha without putting it through Rajya Sabha. Now that is questionable. Okay, and many opposition members have basically leveled this allegation against the government that you are passing ordinary bills as money bills so that those bills are not scrutinized in Rajya Sabha. Right? This is the controversy. So this controversy is currently pending in court. So court will take a decision on that. But for us, what we need to know is what is money bill. So let's talk about it. Okay. So money bill. Okay. Now the definition of money bill is given in Article 110. But Article 109 says that, just a second, that money bill shall be introduced only in Lok Sabha. It shall only be passed by Lok Sabha. Yes, after passing through Lok Sabha, it shall be forwarded to Rajya Sabha. If Rajya Sabha rejects that bill, it would have no effect. That bill would have been passed. If Rajya Sabha proposes some amendments and Lok Sabha says no amendments, that bill would be passed. If Rajya Sabha doesn't resend it, if Rajya Sabha keeps it with itself saying we are discussing, and if it keeps it with itself for more than 14 days, then too that bill would have been deemed to be passed. So Rajya Sabha has no power. This is mentioned in Article 109. Now, what is a money bill? The definition is given in Article 110. So let's talk about Article 110. Okay. Article 110 provides a strict definition of money bill. In order for a bill to be designated as money bill, it must contain only provisions dealing with all or any of the specific list of subjects. So Article 110 basically mentions those subjects which, if are part of a bill, that bill would be called money bill. Now we'll talk about those subjects. Okay. Article 110 clause 3 says that if there is a controversy with respect to whether a bill is a money bill or not, if people disagree whether this is a money bill or not, then the decision shall be taken by the speaker and his decision shall be final. And generally, speaker is from ruling party. That is why opposition members say that they are passing ordinary bills as money bills because the speaker is calling it a money bill, but it is not a money bill. But because speaker is there, they are passing it as money bill without scrutiny in Rajya Sabha. That is the controversy and that is a petition in the court. Okay. Now constitution is clear. Speaker's decision shall be final. Now the court is deciding whether this word final means actually final or there is a scope for judicial review. The courts are deciding on this. Okay. Now what are those subjects which should be a part of that bill for that bill to be a money bill. Okay. So if that bill is related to taxation, financial obligation of Government of India, any debt on Government of India, Consolidated Fund of India, okay, Contingency Fund of India, or any matter related to these subjects. If the bill contains these subjects, then that would be a money bill, and the decision of the speaker shall be final. Clear? That's it. That's all as far as the money bill is concerned. And last topic is, well, Enemy Properties Act. Okay. Now, Enemy Properties Act is basically, well, it deals with properties of those people who were before partition, well, Indians, but after partition left India and became Pakistani citizens. Now, their property is considered enemy property. It is taken over by the government and disposed of by the government as the need may be. Okay. Now, how the government will take over that property, how the government will dispose of that property, well, law related to that is Enemy Properties Act. So, Enemy Property Act regulates that. Now, this particular issue contains various provisions that you have to cram. Okay. There is no understanding required. Okay. You need to remember a few facts. Therefore, I won't spend time discussing this because it doesn't require any conceptual understanding. But in your notes, I will mention each and every detail. So, do revise this Enemy Properties Act from the notes. Okay. You just have to remember it. Okay. But it doesn't require any conceptual understanding. That's why I'm not spending time on it. Clear? Okay. And with that, we conclude today's session. Thank you so much for watching, everyone. I'm sure it has added value to your preparation. But do not forget to revise and practice the MCQs. Okay. On that note, I'll be signing off with the promise of seeing you again with Prelims Powerplay Polity lecture number 3. Okay. Thank you, everyone.